I wanted to talk a little bit about what the court was talking about a moment ago. For the people that may not have read these laws, this nice lady gave law writing power to this nice gentleman in the executive branch. But what are the rules that he has to follow if he wants to issue an emergency order? Under 2453, which the court struck down on the state counterpart, just that there's an epidemic and it is necessary to protect health, he issues the emergency order. But who gets to decide the emergency? The people? No. The executive branch decides the emergency. So they control the definition of the emergency. 2451, declare that there's an imminent danger that a condition could reasonably cause disease. That's it. Once they make that determination, they can start issuing orders, closing restaurants, having us wear mask mandates, whatever else they want to do. But you see, as the court is well aware, this is the danger James Madison does not want. That branch has the power of enforcement, and that's where the difficulty lies. We want this officer to have a firearm because he must enforce the law, but he doesn't get the pen. He doesn't get to write the law. He gets to enforce the law. And this nice lady gets to write the laws. She has a lot of power, but she doesn't get a firearm. She can't enforce the law. And then the court gets to interpret those laws on the constitutional basis. So 2451 also allows them to prohibit the presence of individuals. Very broadly drafted, no definitions. 2455, any building that could reasonably believe to be the cause of disease based on the condition. Now that's going to be a restaurant, or better yet, a school. If they find that COVID or some other disease or loneliness or anything that's an epidemic, they can close the school under 2455 because the building itself is the cause of the disease. 5201, if the officer reasonably believes that somebody harbors an infection, whether or not it's present. So you just look at somebody, and the other criteria is there an unwillingness to conduct himself in such a manner as to not place others at risk? That sounds a lot like COVID and social distancing. And
It seems to me a lot more clear guideposts than reasonable and necessary, though. Would you agree?
Yes, but it fails the definition of a law judge because it's not a law yet. And the law must be a law when it leaves Lansing. That's it. It can't become a law. And the law writing belongs to the legislature, but by doing this, they're giving the executive branch broad powers to write laws when they feel like it.
Well, it appears you recognize that there can be some sharing between the coordinate branches, so long as the delegation does not violate the anti-delegation or the non-delegation doctrine. You cited the case, the imminent case from the Michigan Supreme Court.
Right.
You cited it and relied upon it in your brief. It says that you can have that coordination, you can have the delegation so long as there's some reasonable exercise of discretion or channeling of the exercise of discretion, right? So the question is, does 33.5201 have more guideposts which channel the exercise of discretion of the director, local health director, the NDHA's director or otherwise, more so than 2253, which I struck down?
I think that 5201 has the word reasonably believes, and that word struck down the Emergency Powers Act. And the court got the other half of that equation by the word necessary. Reasonable and necessary were in that statute, and both those caused the demise of the statute. The court only had necessary, and that was struck down. So this is reasonable. I think reasonable is worse. It's more broad. It's in the mind of the person. And those that support the delegation of law from one branch to another, and I have found less support for that over the years, Judge, having done this for 4 years now, that I'm not the biggest fan of the non-delegation doctrine that I used to be, because it can be manipulated, and I'll come to that on the vesting clauses in a moment. But that is the law under NRA certified. But these also fall for indefiniteness. There's no time restriction here that how long these mandates can stay in place. And that causes the fatality of it. And the same with 5203. if you're determined to be a health threat to others, you get a warning notice, and it can be oral, just a verbal notice, and you're required to cooperate. I don't know what that means, but it's very broad. Then it goes on to say they can require treatment programs and require medical testing. But these laws were well intentioned in 1978, which was a long time ago, but they were never used.
Would you agree that 5203 is more protective to the individual than, for example, 2253? For example, 5203 allows the department to issue a warning notice. It allows the department to say what an individual must do, engage in testing to make sure whether there's a disease and so forth. But then for enforcement, they need to apply to the probate court. And then there's the due process right. That was an opportunity to be heard. Would you say that's more protective or less protective?
It's more, it is, right? You have the right to go to the probate court. And ironically, one of the suits I filed in this county on the school mask mandates, I filed in the probate court. And Judge Cooper looked at it and said, no, I don't have the jurisdiction. We came to this court. Judge Briscoe decided that case. So now I'm concerned about that because I did go to the probate court and I was told we don't have jurisdiction. So now what happened? And that was a written opinion by Judge Cooper. So now we have precedent in this county that really the probate court doesn't have the authority.
Well, but that wasn't on this section, right? You didn't file suit under 5203.
Yes,
You did.
I did. And cited that probate section.
All right.
So-
Judge Cooper determined that the probate court did not have jurisdiction, so that.
That's correct. Yeah. And so that is Let Them Breathe versus local health department, and that would have been filed in 2021 in September. So the court should be able to find that, or if you ask me to submit that to your staff, I'll do that. So the court said more of a probate court on wills and trusts and those types of things, and the county argued that he lacked jurisdiction. So he came to this court, under the circuit court, and I still believe that the probate court is the proper venue, but I hear
Whether or not it's probate or circuit, though, that the individual citizenry has the ability to address the grievances in court. Does that make 5203 better able to survive a non-delegation challenge?
it's got a better shot at it. I'm concerned about the earlier language in there about that they get a statement that requires the individual to cooperate. A person could just cooperate and not know they have a right to go to probate. About that. And what happens, Judge, if the health department issues an order under, and they cite 2453, 2451, 5201, 5203, and 2455. Now we've got a basket here, which is what happened on the mask mandates in the school cases. They racked up all those statutes, 2453 and 2451 for sure in the danger. So then what happens to the basket? Half are clearly unconstitutional and some are more suspect. But I stand on the premise that they're going to need a lot more guidance if we're going to allow delegation. And what they should be doing is, which is in my complaint, and we just have some limitations on our briefing, is fact finding. If the legislature says to the executive branch, if you find these facts, you can then issue this order. But I want to see court relief in 2453 and 2451, 2455. The elephant in the room is the legislature has the power right now. So if this is what the public wants, then write a law that would require mandates under certain circumstances. But as I think the court just pointed out, 2453 was the most dangerous because you can prohibit the gathering of people for any purpose, just when it's necessary for an epidemic. And if we were getting cases in which the courts were saying they were moot until T&B. And T&B said, we need to decide these cases. And so did Ottawa. And now the Berkey case out of the U.S. Supreme Court most recently.